My name is Kate Brady, and I'm the Immigration Department Head at the Constitutional Law Center for Muslims in America. I'd like to welcome you to today's webinar, and this is on the acquisition of citizenship for children who are born abroad. It's kind of complicated, and so hopefully we're going to step you through some of the most common situations, and then I will take a little bit of time to overlap that with what CLCMA does, and then we're going to talk about what we do as an organization. So we are ready, and let's get going. So these first couple of slides give you multiple scenarios for children who are born abroad. This first one is talking about children with married parents. And as you can see that there are variations on that, where either both parents are citizens, one is a citizen and a national, and the other is for a citizen and a non-citizen. There's different physical presence requirements, and the really important thing is that in wedlock is determined legally married at the time that the child of conception, or if the birth was within 300 days of the termination of that marriage, either death or divorce. And it has to be married and legally parents per local law. So that might come up a little bit, maybe like with like a section or something like that. And there is a recent policy change on that first one to U.S. citizen parents about one parent must be a resident of the U.S. prior to the birth. If you look down at the bottom, there's a little bit of a help here at the uscis.gov site. There's going to be 4 charts that we're going to go through, kind of the scenarios that are on these charts. If you want to go back and look at them, you can do that. What I will say is I'm giving you a snapshot of what the law is right now today. This changes all the time. So whenever this question comes up for me, I always have to get the most information as possible about when that child was born and all of the other factors surrounding that, because it changes over time. You'll see a little bit of that later. So this next slide is about unmarried parents of those children born abroad, again in multiple scenarios. Both parents citizen, the citizen is the mother and the citizen is the father. The resident requirement is the same as it was when there was an in wedlock child born, but there's also now for the one parent who's a citizen, a physical presence requirement of 5 years prior to that child's birth, at least 2 years which were after the age of 14. This was a recent requirement in 2017. And then for the child who only is citizen father, they have a legitimation requirement. And that's because you can be the biological father, but not necessarily have a relationship with that child. And so that's the important part here when we talk about legitimation. So what does that mean? What that means is that there needs to be a blood relation between the child and the father, and that needs to be established by clear and convincing evidence. A lot of times you're going to see people providing DNA to make that clear and convincing evidence. And it's important that the child's father was a citizen at the time of the child's birth. So after acquired citizenship does not allow for this child to be a citizen at birth. We're going to talk a little bit about some acquisitions if that happens later, but not in this case. And then there's also a requirement for financial support of this child until that child reaches 18. This needs to be acknowledged in writing. It needs to be also the paternity established by a competent court. And this is controlled by where that child has their residence. So if you do have a child who is born abroad who is a citizen by birth, that means that the parents have met the requirements for transmitting that citizenship, and the child is eligible for what we call a consular report of a birth abroad. That happens because the child has a birth certificate of the country where they were born, but now also the U.S. is allowing for them to have evidence of that birth through the Department of State. And that is done because they're going to actually get this report, and it's going to look kind of like what a birth certificate would have looked like. It must be acquired before the child reaches 18. That does not mean that if you don't get it, that the child is not a citizen. It just means you're not going to get that document, which is not a travel document. If you want that child to travel to the U.S., you must also submit a passport application to the Department of State. And for that appointment, you have to have both parents there unless one of these exceptions happens, such as only one parent is listed on the birth certificate. There is a court order granting sole custody and no access by the non-custodial parent, or the non-custodial parent has been declared judicially incompetent or has died. So if there are any other reasons why that parent is not there, you will need to have a notarized statement of consent. So they're not an exception, but they're consenting to that application for the consular report of birth abroad by the one parent who is physically attending. So this next one, the Child Citizenship Act of 2000, that we a lot of times abbreviate as the CCA, this one is really exciting. So this is a child who was born abroad, and typically where the parent was not able to pass citizenship on because they were not born in the US, maybe they naturalized later. So that's the most likely scenario here. But that child was born outside the US after February 27th of 2001, and they are automatically a citizen when these happen. So not at birth, but when these happen. At least one parent is a citizen, and the child resides in the US in the legal and physical custody of the citizen parent, pursuant to a lawful admission as a permanent resident. So these all have to be met prior to the child reaching 18. But the excellent thing about this is even if they are meeting all of these requirements by their 18th birthday, they don't have to necessarily claim their citizenship prior to their 18th birthday. They are still a citizen by law under the CCA. And that's this chart 3. Prior to that time, there was a different law, and that was under the former INA one. And this one was a little more difficult because both parents had to be citizens. And that meant that if one was already a natural born citizen or a naturalized citizen, the other one then had to naturalize. The child still has to be under 18 at the time that the second parent becomes a citizen, lawfully admitted as a permanent resident, and permanently residing in the United States. Again, all these conditions can be met before the child is 18, but regardless of when they discover it, they are still a citizen. I had a really exciting time when I figured this out for some clients who'd come in because this adult was going to naturalize, and we went through the questions, and I talked about, well, are either of your parents citizens? And she said, yes, both of my parents are citizens. Well, when did that happen? Oh, I was about 14 or 15. So we immediately stopped her consultation for naturalization. I said, but you're already a citizen. And I showed her the law, and we thought that was great. So she and her 2 adult siblings, including her fraternal twin brother, all were able to get their passports because they were already citizens, having met these requirements. That was an exciting one. So they were eligible for that passport. All of them got it. And if you want to explore whether any of this is something that might have passed citizenship on to you or your children, that is something to talk about. You look at the law of when it happened. So this is an expedited naturalization of children that we're going to talk about. So this means they didn't acquire it at birth, and they didn't acquire it through the CCA or the former INA 321, but we're going to expedite your naturalization. So you're going to become a citizen as fast as we can through a child's naturalization. You're under 18. At least one of your parents was a US citizen by birth or naturalization. And there is a bit of an exception if that parent is deceased, that your grandparent can step in. And the citizen parent had to be physically present in the US for at least 5 years, 2 after the age of 14, unless they were a service member. You have to be lawfully admitted to the US, but that does not mean as a permanent resident. So a scenario might be that your alien parent comes as a student and you were their dependent, or maybe as a worker and you were their dependent. And then you're going to maintain that status and your physical presence in the US. If you are over the age of 14 and you are a naturalized citizen through this expedited process under INA 322, you do take the oath of allegiance, which you do not have to do under the Child Citizenship Act or the former INA 321 or any of the consular report of birth abroad qualifying citizens. Again, this is chart 4. So let's talk a little bit about some possible outcomes and pitfalls. So maybe your parents have not met the physical presence requirements. A sad situation I had was somebody who came to my office. She'd been told by multiple attorneys that she was not a citizen, even though she thought she was. She was born to a US citizen mother who was 17 at the time that she was born, but she was born in a foreign country while they were getting the immigrant visa for her dad. And so her parent did not have enough physical presence past her 14th birthday to pass on that citizenship. She had to immigrate, even though she'd been in the US her whole life and thought she was a citizen. So they may not be the child may not be in the US citizen parent's legal custody. This has happened to me before when there's been a divorce and the US citizen naturalized here in the US after the divorce, and then the child was legally residing in the foreign country and visiting on holidays. So we were unable to have that child be an expedited citizenship through the Child Citizenship Act. She actually had to wait until she was an adult and had her physical presence, and then she was able to apply for her own naturalization, which was successful. And then if your parent was deceased, you might need to use some of the exceptions. And this is a big one. If your parent committed fraud when they were naturalized, you could actually have your status stripped because they could not then have passed on derivative citizenship. We have a case here at CLCMA where we litigated that and had a settlement with the government so that the children could actually retain their status in the United States. That was a long time to negotiate it, probably over a year, and it was a hard-fought win, and we were very that outcome. And then if you were a derivative child who then goes outside of the United States, you may not be able to pass your citizenship on to somebody else, or if you were even a natural born child and didn't have enough physical presence. So I've seen that happen before where somebody was maybe an infant or a grade school age child, and then they left and either lived with their parents or grandparents abroad, and then they had children abroad. They were not able to pass along their citizenship. So as I said a little bit ago, you can actually lose your derivative citizenship if there's some fraud on your parents' case. Not if you were born abroad and were a natural born citizen as a consular report of birth abroad, or if you were having your birth between at least one of your citizen parents and they pass their citizenship on. But if it was through a naturalization of your parent, such as under the INA 321, that could happen if there was some fraud. And there used to be a retention requirement that has ceased as of 1952, but that used to be, people would ask me all the time, well, how often do I have to come back to the US? And I would say, you don't have to anymore if you were born after 1952. And even though as a derivative citizen or a citizen born abroad, you cannot be deported, we do have ICE make that mistake. We had a Dallas case pretty recently where there were two brothers who were minor children, and they were driving in a car to a soccer tournament close to the Mexico border. One of them was born in Mexico and one of them was born in Dallas. They had an agreement with the one born in Mexico. He agreed to leave. The other one claimed to be a citizen, so they actually put him into deportation proceedings and into detention until he could prove through an attorney that he was actually a natural born citizen. So also, even if you're born in the US, some people born in the US are not citizens because they were born to diplomats and they are not subject to the laws and jurisdiction of the US. So that is an issue there, that they cannot actually, even though they were born in the US, be a citizen. So let's talk a little bit now about how immigration generally will intersect with what we do, which is impact litigation. Impact litigation is in the federal courts. And what we mean by that is we take the subject matter, such as immigration, which is complex and broad, and we actually overlay that with litigation. We're going to talk a little bit about the subject matter of our litigation. We also have civil rights litigation in our civil litigation section and criminal litigation in the criminal section. And then we also have a non-litigation section of the non-practice group that does trainings and boot camps for active nonprofit organizations to make sure they're in compliance and give them some tips and tricks. But what we do is what most immigration attorneys do not do. What I would call what most immigration attorneys do is what we call petition-based, meaning they make an application for citizenship. They apply for your non-citizen spouse to come here as an immigrant. They help you with maybe a worker visa. And for those, that is what most immigration attorneys would do. But impact litigation, which is time intensive, is what we do. And let me tell you a little bit about how that happens here. So we have hundreds of client intakes across all of our practice groups. We will screen those, have a consultation with an attorney, internally make a recommendation, and if we think it's one that could be a good case for litigation, we will take that to our board of directors and they will make a vote on that. If they vote that we have the resources and that you're a good one for our impact litigation, you will be approved and you'll become one of our cases. And we get excited about those because what we're really trying to do is fight against discrimination and injustice from our US government. We want to identify situations where there's been violations of the US Constitution or civil rights, a lot of times in the area of national security on the basis of race, country of origin, or religion. And so we do accept fewer cases because we know that when we do that, we are going to be able to use that one case to make a broad impact. And the reason why we can do that is because good facts make good law, and other cases can benefit from that. And we have a finite amount of resources here, and we want to make sure that we are taking those cases that can make the biggest community impact. So you may be wondering if you even need an attorney. I would say in this specific instance about whether your child is a citizen or not, it is something that I would almost always recommend you at least consult with an attorney. You may not need an attorney to get the actual document, but you need to know whether or not they qualify. Because sometimes you have other forms of immigration benefits that might be more form-based, and people might think that that's easy, or that their relatives did it, or that it costs too much to go to an attorney. But I can tell you that there are a lot of complications when you look at immigration. And I would strongly recommend that you at least consult with an attorney, whether it's us for an impact litigation case or a general immigration attorney if you have a case that you just have more broad questions. And that way you can know whether or not you are moving in the right direction. So if you need that ability to talk to a general immigration attorney, what I do personally in my immigration section is I am going to give you some resources. These are the general resources I give, and this is a lot of times I will make these a little more customized for where you live. So I would hope that you've enjoyed what we've talked about. I know it's very complicated, and the answer is let's look it up, let's look at the facts, but hopefully you have learned a little something out of this and the other webinars in the immigration and the other sections that I've done, and hopefully you're watching all of these. And we really appreciate the time you're taking. We are grateful for what you do for us and hope that you will be able to support us and that we will be able to give you more information. Again, my name is Kate Brady. I'm the Immigration Department Head at CLCMA. If you want more information about what we do or think you have an inquiry that would be impact litigation in immigration or civil litigation or in criminal, please do make an inquiry. And if you have a nonprofit organization that you would like to have more information about our nonprofit practice group, we would appreciate that you would go to our website and make that inquiry. Thank you.